we're discussing two recent family court decisions that may impact your family or maybe a family you know. And joining me again is Jared Teitel, family lawyer with Normandin Chris firm here in Toronto. Jared, two very interesting cases, similar outcomes if you were to ask me. What do you think the takeaway is from these two cases?
So I think the big takeaway, in both cases, there was one parent in favor and one parent not in favor of the vaccine. And in both decisions, the court really favored what's best for this child, but more so let the child make the informed decision. Because under the Healthcare Consent Act, there's no age requisite to be able to consent. It's the test under the Healthcare Act is whether the minor is considered mature. So in both decisions, it wasn't compelling or ordering the parents to vaccinate the child. It was enabling the parents to be able to facilitate the child getting his or her own vaccine.
Okay, and that's a very good point to make. And many families may not be aware of this, but at least in Ontario, and you could correct me if I'm wrong if this is similar in other jurisdictions in this country, but in Ontario, really it comes down to capacity to consent, right? A child, if they show capacity to consent, then they can consent to their own medical treatments. There's no prerequisite age. It's not defined as to what age. Is that correct?
That is correct. The healthcare consent specifically uses the term mature minor, but that's a very subjective circumstantial test. But the rationale behind it is, as you just say, to not set a specific age and to give children more authority and personal autonomy in their healthcare.
Okay, so tell us what happened in these two cases.
So in both cases, one parent was in favor and one parent wasn't in favor. But the decision out of Ottawa, the child was 14 years old, and the child initially wanted to be vaccinated. The child had an appointment with their medical doctor and had a conversation there. And then the details we have from the decision is that the child's mother did not want the child to receive the vaccine and was having a lot of conversations with the child, sending a lot of articles to the child. And it reached the point where the children's lawyer was appointed to advocate and to present the child's views and preferences in court. And the child's position actually changed one day before the hearing from wanting the vaccine to not wanting the vaccine. And
Wow.
The judge picked up on the child. The child's views were not the child's own. They weren't independent. The court found the mother was influencing the child's views based on the child being able to suddenly having a change of mind, but not being able to justify or explain why he suddenly didn't want the vaccine. So the court actually went and made an order to enable the father to have the child vaccinated, but specifically made an order preventing the mother from speaking to the child about the vaccine issue. It goes further than that. The mother can't send articles, can't send anything on social media or text or have these conversations. But the thrust of the decision was to enable the child to make an informed decision about the vaccine, free from any noise from either parent.
But isn't that the role of the parent when you're helping your child navigate issues in life, to make these informed decisions, to provide them some information, maybe balanced, maybe one-sided, I don't know, but what's could be so criminal about that?
So that's part of the big issue here. And it comes down to the ultimate test in all these decisions is what's best for this child.
Right.
And our courts have already taken what's called judicial notice, which is a fancy term for a court accepting certain facts at face value without a party having to specifically prove them. And by that, I'm referring to the newsletters and releases from Public Health Canada and Ontario with respect to the recommendations for vaccines and their efficacy and the validity of such vaccines. But what I find quite fascinating is we're seeing the courts put the child in the driver's seat about that decision to be able to make his or her own informed decision.
Okay. And now with this other case, we had a case of 14-year-old boy, but they're triplets, 3 boys, 14 years of age. What happened there?
So that was another interesting one. We have triplets, 14. One was in virtual school, 2 were in in-person school. The decision does not say why. That decision's interesting because the 2 children from the onset wanted to receive their vaccine.
And they lived with the father. I think
I believe so.
Yeah,
that's
the two who were in virtual school lived with the father, and the one in-person class lived with the mother.
That's correct. So the two with the father wanted to receive their vaccine. They were united in that viewpoint, but they couldn't because their mother had their health card, and the mother wasn't providing the health card to the children, so the children weren't able to get it. So that case, there wasn't a discussion about undue influence or the independence of the child's views, that was accepted, at least from how we read the decision. So for Justice Charney, in that case, it came down to crafting an order to ensure that father had the health cards to give to the children so the children could go get their vaccine.
Okay.
But in both cases, just to summarize, in both cases, we're seeing the court place the child in the driver's seat in terms of making that decision.